Crystal?
To give you a sense of the scope of the changes brought about by the 2020 General Assembly, I believe that they are the most significant in Virginia employment law, even more significant than all of the cumulative changes that have occurred in the 35 years. This is a fundamental change of Virginia from being one of the most pro-business states to now moving to what I would view as one of the 5 most liberal states, most pro-employee states in the country. Today is first, Crystal, if she's back on at that point, will cover 3 wage statutes that were modified by the Virginia General Assembly. There's a new minimum wage act with significant increases. The wage payment law imposes some new significant requirements, and the pay transparency law. And then I am planning on covering the drastic expansion of the Virginia Human Rights Act and the whistleblower protection law that was enacted. When we come back again in a couple of weeks on July 14th, we will talk about the new restrictions on use of non-compete agreements, marijuana decriminalization as it affects employment. We'll also talk about the worker misclassification laws. There was a package of laws relating to that. And we'll also, I'll address briefly, you should be aware of the changes which will allow public sector bargaining. It's a whole new law, legal environment for Virginia employers. We're going to talk about the new or revised laws and the consequences of those. And then we will offer some actions that employers either have to take because of a change in the law or that they should consider taking. Okay, Crystal, are you on board again?
I hope so. Can you hear me? Yep.
Okay.
Okay, good.
And Diana, go ahead and switch to the next slide if you would. Oh, and move on to the next one.
I think I lost you again.
You're on, Crystal. Go ahead.
Crystal, are you there?
Are you muted, Crystal?
She's not muted. She may have gotten.
Okay. My suggestion would be that we go ahead and scroll forward to the orange slide that addresses the Virginia Human Rights Act, which is up at about slide 20, around 20. There you go. Okay, thanks. We'll jump right into this if you don't mind. Okay, next slide. The Virginia Human Rights Act has been in effect for a number of years until June 30th. It created a very limited what we call a private right of action. In other words, an entitlement to bring a lawsuit on behalf of an employee. But this statute was, for a long time, limited to small employers, 6 to 14 employees. The reason it was cut off there is because federal anti-discrimination laws kicked in at 15. So this was designed to be a limited supplement to the federal laws applicable only to the employers too small to be covered by federal laws. Furthermore, it only addressed discharges. It only allowed an employee to bring an action if they had been discharged on a discriminatory basis. It covered all of the same general characteristics, race, color, religion, national origin, those which were covered by Title VII. And for age, it was limited to employers with 6 to 20. And again, that's because the federal law kicked in at 20. Next slide. The statute was very limited in the remedies that were available. An employee could get a total of 12 months of back pay. They could get attorney's fees, which were capped at 25% of the back pay award, and they could get no other damages. They could not get compensatory, punitive. They could not get a court order for reinstatement. and the statute specifically prohibited anyone from bringing a wrongful discharge claim based on the Virginia Human Rights Act. The net practical effect was that plaintiffs' attorneys ignored this statute, made no effort to pursue claims under it, and only were interested in claims that could be pursued under the federal employment discrimination laws. That meant that they had to go to federal court, but they just ignored the Virginia Human Rights Act because there really wasn't any great advantage or purpose for them in doing it. Next slide. Next slide, there you go. Now, with the 2020 amendments, there are both substantive amendments to the law as well as procedural. The substantive are on the surface, and I presume that most people listening will think that that's the most important part. It may be important, but it does not have nearly the impact that the procedural changes will bring about. But first we'll go through substantive. It now includes sexual orientation as a protected characteristic, and it includes gender identity as a protected characteristic, and it includes veteran status as a protected characteristic. Veteran status has long been protected under federal law, and now it's protected under state law as well. If you go to the next slide, Diana. Now, I do want to point out the addition of sexual orientation and transgender status is not as significant now because just 10 days ago, the U.S. Supreme Court handed down a decision in Bostock versus Clayton County that essentially expands the coverage provided under Title VII. So sexual orientation and transgender status are now protected under both state and federal law. Next slide. Substantive expansion again, because, and this is one where Virginia is really out on the cutting edge of progressive view. Because of race, for purposes of discrimination, has now been expanded to include traits historically associated with race, including hair texture, hair type, and hairstyles such as braids, locks, and twists. That's all part of the statute. If you have for instance, a grooming code that would be enforced as prohibiting certain hairstyles, that may well be the basis for a race discrimination claim being brought under the Virginia Human Rights Act. This is specifically part of the statute. There are only 3 other states in the country that have adopted this kind of legislation. It's sometimes referred to as crown legislation, hair texture, hair type, and hairstyles. All right, next slide. Substantive definitions have also expanded. Pregnancy, childbirth, and related medical conditions now includes lactation as a protected characteristic. That will be more important when we get to a future slide explaining the duty to reasonably accommodate pregnancy, childbirth, and related medical conditions. Next slide. Here it is, the reasonable accommodation. This is very detailed. You need to be aware of it. This is all part of the statute. Reasonable accommodation must be provided to applicants or employees experiencing pregnancy, childbirth, or related medical conditions, including examples. These are in the statute. More frequent or longer bathroom breaks, breaks to express milk, access to a private location to express breast milk other than a bathroom, acquisition or modification of equipment or additional seating, temporary transfer to a less strenuous or hazardous position, assistance with manual labor, job restructuring, modified work schedules, light duty assignments, and additional leave time to recover from childbirth. Those are all identified in the statute as examples of reasonable accommodation that must be provided by an employer. Next slide. Continued on the substantive expansion of the act. Understand that the current version of the Act only addressed discriminatory discharge. Now it covers everything the same way Title VII does, failing or refusing to hire or otherwise discriminating against an applicant or employee, limiting or segregating or classifying applicants or employees in such a way as to deprive them of opportunities or adversely affect them. These are the other Title VII categories. Next slide, Diana. It also prohibits using a protected class as a motivating factor in an employment action, even if other factors also motivate the action. So we're not focused under the Virginia law on the critical factor or the dispositive factor. If any of these protected characteristics are a motivating factor in an employment decision, then it's unlawful. It's also publishing advertisements that are discriminatory or suggest a preference. That of course, addresses things like using phrases 30 years ago. I talked to the association about not having ads for the categories of, I used to give the examples of young man to learn dry cleaning business or a gal Friday for small office. Those have been illegal for 35 years under federal employment discrimination laws. This is just making sure that the Virginia statute at least comes up to the same level of protected, prohibited conduct as the federal statute. For small employers, those with 5 to 15 employees, you can breathe a sigh of relief. The statute is limited to unlawful discharge as it is under the current law. Next one. Okay, if those didn't sound dramatic enough, it's the procedural or remedial expansions of the Act that are the most significant. For employers with 15 or more employees, an action can be brought for any unlawful discrimination, not just discharge, and can recover unlimited compensatory damages. Compensatory are pain, suffering, humiliation, loss of enjoyment of life. Punitive damages, which are probably capped under another state law at $350,000, unlimited attorney's fees and costs. And injunctive relief can be awarded as well. Typically, the Virginia General Assembly does not create much in the way of any legislative history, so some of these things we don't know exactly the detail. The availability of injunctive relief is, the statute says it's available in exceptional circumstances, but it doesn't tell us what exceptional circumstances are. So there will be cases over the next year or two that advise when a court may be able to grant injunctive relief on this. But unlimited compensatory damages, if you heard a bell going off with the plaintiff's bar suddenly bringing their interest back in bringing cases under the Virginia statute, that's it right there. Unlimited compensatory damages. Next slide. For most claims, individuals have to file a charge of discrimination with the Virginia Division of Human Rights, which is part of the Virginia Attorney General's office, or with the EEOC. It'll go through something of an investigation, although the state agency has never really conducted much in the way of investigations in the past, but the General Assembly didn't worry about that. Upon receipt of a right to sue after the investigation or after 180 days, the individual can bring an action in Virginia General District or Circuit Court. There are, again, several items that are not specified in the statute as far as how long a period of time they have after a discriminatory act to file a charge and filing suit after a right to sue is issued. Best guess is that they will use the same timeframes as apply for EEOC charges. That's 300 days to file a charge and 90 days after issuance of a right to sue to file an action in court. Next slide. I want to point out, and the reason I was emphasizing that pregnancy, childbirth related medical conditions, for a claim of discrimination based on that, whether it's discriminatory treatment or failure to provide reasonable accommodation, there is no requirement of filing a charge of discrimination. As soon as the claim arises, a person can file a lawsuit in court. Next slide. Okay, they will, as I say, this will lead to a huge shift. Cases have routinely been filed in federal court. Now they're going to be going in state court, by the way, before judges who have never heard discrimination cases in the past. But that they need to learn the procedure because these cases are going to be heard overwhelmingly by juries on it. As I mentioned, 2 bullets down, juries come from within the jurisdiction of a court. When a case has been filed in U.S. District Court in Richmond in the past, the jury could come from as far away as Fredericksburg or the Northern Neck or down on the North Carolina border or as far east as Williamsburg. Now, if it's a case filed in Richmond Circuit Court, it will be a Richmond Circuit Court jury. A very significant difference between state and federal court is that many cases in federal court are disposed of on something we call summary judgment. It's motions argued by lawyers that allow cases that don't have anything to be decided by a jury to be disposed of without going to trial. The state laws in Virginia effectively preclude summary judgment. And so that means that if a case is filed, there's one chance at the beginning to file something called a demurrer to say that this is not even a legal claim. But once a case goes by a demurrer, it will go to trial unless it's settled. There really is no other way to dispose of it short of trial. And that leads to the bottom bullet, which is that plaintiff's counsel will have much less incentive to settle. Typically, in federal court discrimination cases, you had an opportunity to settle before or while a summary judgment motion was pending. Plaintiff's counsel don't have to worry about those, so they have much less incentive to settle and are more likely to go to a trial, hoping that they can get those unlimited compensatory damages. Next slide. So what do you have to do under the statute? Some revision of your handbook is required. Some may just be prudent. If your EEO policy currently lists the protected characteristics, you need to modify it because now there are additional protected characteristics. If your policy just says we prohibit discrimination on all grounds protected under state or federal law, then that would be sufficient. You are affirmatively obliged to put in notice of the duty to provide reasonable accommodation of pregnancy, childbirth, and related medical conditions and the lactation provisions. It has to be put in the handbook, and notice has to be provided to an employee when you become aware of pregnancy. It is appropriate to review the handbooks on other provisions. Certainly a time to review any internal complaint procedure, any internal process that you have for reviewing terminations. As I've been saying for 30 years, employers don't win employment litigation. They win by avoiding employment litigation. So anything and everything that you can do to avoid charges of discrimination and lawsuits, you should do. It is I think, a very wise time to consider adopting agreements to arbitrate claims, because when you have juries that are asked to provide unlimited compensatory damages, you want to look for every opportunity that you can to avoid going in front of such a jury with such a claim. Agreements to arbitrate and specifically to waive class claims have been enforced by the U.S. Supreme Court, and I think it's a prudent step to take. Next slide. Okay, the whistleblower law. Crystal, are you back on?
I think so for now.
Okay, while you're on, let's jump back to yours. And
Okay.
Diana, that goes back right after the introduction. Sorry if we're making you dizzy, folks, by going through all of these.
Sorry. As David mentioned at the very beginning, there are several laws that were enacted that will change or impact employees' wages and their payment of wages and their ability to seek recourse if they are not properly paid. So let's start first with the changes to the Virginia minimum wage law. Okay. The Virginia minimum wage will increase to $12 per hour by January 1st, 2023. That is a definite, and that is in the legislation that was passed. That means that the Virginia state minimum wage will surpass the federal minimum wage rate for the first time in the state's history. The increases to minimum wage will be gradual. Under the new law, the minimum wage in Virginia will increase to $9.50 per hour, effective May 1st, 2021. Will increase to $11 per hour on January 1st, 2022, and $12 per hour as of January 1st, 2023. So those are the guaranteed wage rates, minimum wage rates that are going to occur between now and 2023. The legislation also includes provisions that could ultimately increase the state's minimum wage rate to $15 per hour by January 1st, 2026. But those provisions must be reenacted by the General Assembly prior to July 1st, 2024 for that to occur. If the General Assembly fails to reenact the provisions by July 1st, 2024 deadline, the minimum wage rate will continue to increase after January 1st, 2025, but it'll be at a slower rate that will be tied to inflation. The new minimum wage rate law also includes a training wage rate for short-term training programs. Under the law, Virginia employers may pay employees a training wage at 75% minimum wage for employees in on-the-job training programs lasting less than 90 days. Please keep in mind, though, that there is also a federal minimum wage law, and where that is, the employee would be entitled to the higher of the two minimum wage rates. So even if the employee can get 75% of the minimum wage rate under state law, whatever that is, you still need to make sure that you comply and that they are getting at least the federal minimum wage rate during that training program time. Okay, next slide, please. The new minimum wage law also creates categories of individuals who are exempt from the state's minimum wage requirements. Significantly, the new law removes exempt status from various categories of workers who were previously excluded from state minimum wage requirements. Among those who are no longer exempt under the new minimum wage law are home care workers, individuals employed in domestic service or in a private home, individuals who normally work and are paid according to the amount of work done, i.e. piecemeal workers or piece workers, individuals whose earning capacity is impaired by a physical deficiency, mental illness, or intellectual disability. So there's some individuals with certain disabilities. There are certain individuals who are certified to work through a federal program, and those are not excluded from the federal minimum wage rate. Individuals employed by employers with 4 or less employees, and individuals younger than 18 who are under the jurisdiction of a juvenile or domestic relations court. Under the new law, the minimum wage requirement does not apply to persons participating as an au pair under the U.S. State Department's official program, individuals employed as a temporary worker also governed by federal law, and any person who is exempt from federal minimum wage under another federal statute, which covers employees of certain amusement or recreational establishments, organized camps, religious or nonprofit educational conference centers. Okay, next slide, please. And there were also several important amendments to the state's wage payment law that drastically strengthen employees' abilities to combat wage theft. These amendments amend Virginia Code Section 40.1-29, which is known as the Virginia Wage Payment Act. As most of you probably know, the Wage Payment Act regulates the time and manner in which employees in Virginia must be paid. For example, it requires that all employers establish regular pay rates and rates of pay for employees, except for some certain executive personnel. With very few exceptions, the Act provides that the hourly employees must be paid at least once every 2 weeks, and employees who are paid on a salaried basis must be paid at least once a month. The Act also provides that a discharged employee must be paid for all hours worked by the next regularly scheduled pay period following termination. It provides that employers cannot require that employees agree to direct deposit of their wages. And in addition, and important to these new amendments, the law prohibits an employer from making certain deductions from wages and limits an employer's ability to reduce an employee's compensation. As of January 1st, 2020, the Virginia Wage Payment Act also requires that employees be provided with written statements by pay stub or accounting online that show the name and address of the employer, the number of hours worked during the pay period, the rate of pay, the gross wages earned by the employee during the pay period, and the amount and purpose of any of these deductions. Now, most of the laws that Dave and I are talking about today are effective July 1st, 2020. This requirement regarding the written statements of pay and deductions that were taken from an employee's pay became effective January 1st, 2020. Okay, next slide, please. So there are two sections of the Virginia Wage Payment Act that are relevant to the issue of payroll deductions. One provides that an employer may not make wage deductions without an employee's written and signed authorization, except for payroll taxes or as otherwise required by law, such as garnishments. Another provision of the Virginia Wage Payment Act provides that an employer also generally may not condition employment or continued employment on an employee signing an agreement that will allow for the forfeiture of wages. Under Virginia law, a forfeiture means that the employee would lose the employee's wage, salary, or commission because of something that the employee did or did not do. In other words, a forfeiture implies a penalty imposed by the employer as a consequence of some act or omission of some act by the employee. Examples of forfeiture that would constitute unlawful deductions from employee wages as punishment include deductions from wages for such things as failure to punch the time clock or sign a time card, making an employee pay for bad checks or credit card charges by customers, deducting wages or funds from the employee's wages for gasoline purchases by customers who drive off without paying, making the employee pay for broken dishes, lost silverware, or damaged equipment, cash register shortages, or making a deduction from an employee's wage for failure to give advance notice of termination. For example, if your policy requires that the employee give 2 weeks notice and the employee does not do so, and you deduct their wages as a result of that. These would all be impermissible and unlawful deductions from the employee's wages under the Virginia Wage Payment Act. Forfeitures do not include deductions for items that are not caused by an error or omission or offense by an employee, such as the purchase of uniforms, insurance premiums, pay advances, repayments of personal loans received from the employer, and repayment for equipment or other items purchased from the employer. These would be permissible deductions from wages within the meaning of the Wage Payment Act, but only if the employer had written and signed consent of the employee prior to making the deduction. Next slide. And the reason why I wanted to go over those and the deductions and improper deductions from employee wages under the Virginia Wage Payment Act is because the new amendments to the Virginia Wage Payment Act strengthen the employee's ability to combat wage theft, which is the denial of wage or employee benefits rightfully owed to an employee. That would include an employer's failure to pay wages for all hours worked, an employer's failure to pay overtime or minimum wage, or an employer's taking unlawful deductions from the employee's paycheck. First, the new amendments create a private right of action for employees in Virginia to sue their employers for alleged unpaid wages, wage theft, or taking unlawful deductions from wages. This is a huge change in Virginia law. Previously, a Virginia employee had no private right to action to file suit in Virginia courts for an alleged violation of the Virginia Wage Payment Act. Employees who believed that they weren't paid wages for their time worked or that the employer had taken unlawful deductions from their wages had to file an administrative claim with the Virginia Department of Labor and Industry. The department could then investigate the worker's complaint, decide if it had merit, and then bring administrative or court proceedings to recover the wages owed. However, it was within the department's complete discretion to determine whether the claim had merit and whether to pursue the claim or not, either in an administrative proceeding or in a court proceeding. Prior to the amendment, if employees wanted to attempt to recover unpaid wages in court, their only real option were to pursue a claim based on a breach of contract or some sort of unjust enrichment theory. But that's not the case anymore. Effective July 1st, Virginia employees will now be able to sue on their own behalf for violations of the Wage Payment Act. Next slide. The new wage theft law provides for strong remedies. A successful employee can recover the amount of unpaid wages due, plus an equal amount for liquidated damages, and prejudgment interest at the rate of 8%, as well as reasonable attorney's fees and costs. If the employer knowingly failed to pay the wages or knowingly made unlawful deductions, then the employee can recover up to 3 times the unpaid amount as liquidated damages. There's also a potential for a civil penalty of up to $1,000 per violation for employers who knowingly fail to make lawful wage payments. This new law opens up several avenues of increased liability for Virginia employers. Employers will now face claims under the new law seeking treble damages, that's 3 times the amount due for knowing violations, to the extent they fail to pay the required minimum wage or overtime wages, unlawfully deduct from employees' pay, or fail to pay employees for all hours worked. The potential for treble damages and attorney's fees not only increases the damages exposure that employers face, but also incentivizes potential plaintiffs and attorneys to bring these type of claims. The amended law also provides that an employee may bring an action for wage theft individually, jointly with other aggrieved employees, or on behalf of similarly situated employees as a collective action. What that means is there's a potential for a group of employees to join their claims together in a single action. Under the new amendments to the Virginia law, the collective action would proceed using the procedures set forth in the Fair Labor Standards Act. I won't get into the details. There's different ways under different procedures that employees can bring collective or class actions, but the amendments specifically say that a collective action under this law would proceed using procedures set forth under the Fair Labor Standards Act, which makes it more conducive to permitting employees to pursue group or mass claims than under some of the other avenues that are available in certain cases that impose stricter requirements. Excuse me. The potential for treble damages also provides highly compensated employees with significant leverage in single plaintiff pay disputes with their employers. The wage payment statute is not limited to non-exempt employees, and even executives and other highly compensated employees can seek treble damages in compensation disputes. In Maryland, which has a similar wage payment statute, there are reported decisions in which senior executives have obtained treble damages for an employer's failure to pay 6- and 7-figure bonus and equity payments. Now that same claim is available under Virginia law. The new Virginia wage payment statute does not define specifically what types of payments are classified as quote-unquote wages under the law, which will be another area of litigation, creating some uncertainty as to whether the payments like commission, bonus, or stock, or other equity compensation can be recovered under this statute. Next slide, please. The potential for criminal penalties for violation of the Virginia Wage Payment Act is not new, but it's also worth mentioning here. Any employer who willfully and with intent to defraud fails or refuses to pay wages in accordance with the Wage Payment Act can be subject to a criminal penalty. If the amount owed is less than $10,000, the employer may be found guilty of a Class 1 misdemeanor. If the amount owed is greater than $10,000, or the employer has previous convictions for a violation of the Virginia Wage Payment Act, the employer may be found guilty of a Class 6 felony. Okay, next slide. Next slide, please. In addition, in the construction arena, the new wage theft law imposes joint and several liability on general contractors for the non-payment of wages by their subcontractors in certain situations. The measure provides that any construction contract entered into on or after January or July 1st, 2020 will be deemed to include a provision under which the general contractor and the subcontractor are jointly and severally liable to pay the wages due to the subcontractor's employees. While generally requiring subcontractors to indemnify general contractors for this liability, that is waived if the subcontractor's non-payment of wages is a result of the general contractor's failure to pay the subcontractor, or if the general contractor knew that the subcontractor was not paying wages. In other words, the subcontractor will not have to indemnify the general contractor if the reason the subcontractor was unable to pay its employees was due to something that the general contractor did and not paying the subcontractor, or if the general contractor knew that the subcontractor was not paying its employees. Additionally, if the wages due to the subcontractor's employees are not paid, the general contractor may be subject to criminal and civil penalties for which any employer is liable for failing or refusing to pay wages, as we just discussed. All right, next slide, please. There is a non-retaliation provision written into these new wage theft amendments, and it protects employees who report wage theft or institute proceedings against their employer for retaliation. The anti-retaliation provisions prevent an employer from discharging or otherwise discriminating against an employee because the employee has filed a complaint or instituted or caused to be instituted any proceeding related to the failure to pay wages, or has testified or is about to testify in any such proceeding. Now, under the language of this amendment relating to the anti-retaliation provision, it does not appear that employees have a private right of action to bring for retaliation, but it does permit the Commissioner of Labor at the Virginia Department of Labor and Industry to institute proceedings against an employer who has engaged in retaliation. Available remedies under this section include reinstatement of the employee, recovery of lost wages, and liquidated damages. Okay, next slide, please. The new amendments also have expanded the investigative authority for the Virginia Department of Labor and Industry. It authorizes the commissioner, if he or she acquires information during the investigation of the complaint that leads the commissioner to think on a reasonable basis that other employees might not have been paid properly, that the investigators or the commissioner's investigative powers exceed that just which the employee who filed the complaint, but the investigator can look into to see if whether other employees, were not properly paid. The amendments also provide that if the commissioner finds in the course of the investigation that the employer has in fact committed a violation, the commissioner may institute proceedings on behalf of any employee for failure or refusal to pay required wages under the Wage Payment Act. So that means if the commissioner gets a complaint from an employee And in the course of the investigation, the commissioner believes, has a reasonable belief that this is some sort of practice that the employer has engaged in. The commissioner has authority to investigate further and can bring actions on behalf of other employees, even without those employees' consent. The employees don't have to consent to the employer bringing administrative or judicial proceedings against the employer. Excuse me, next slide, please. All right, and there's another new law regarding pay transparency. And that law prohibits employers from discharging or taking any other retaliatory action against an employee for discussing wages or compensation with another employee. This law also becomes effective on July 1st, 2020. Employees are protected when they inquire about, discuss, or disclose information about their own or any other employee's wages or compensation. And they're also protected when they file a complaint with the Virginia Department of Labor and Industry alleging a violation of this law. As some of you know, it was already a violation of federal law, Section 7 of the National Labor Relations Act, to prohibit employees from discussing wages with each other, but it is now expressly a violation of Virginia state law as well. Next slide, please. The new law does not apply to employees who have access to compensation information of other employees or applicants as part of their essential job functions, who disclose the pay of other employees or applicants to individuals who do not otherwise have access to compensation information. In other words, this law does not protect people in HR or payroll from disclosing to managers or other people in HR what employees' wages are if that's in the course of their essential job duties. It would cover these employees, however, if they make a disclosure in response to a formal complaint or charge made in connection with an investigation, proceeding, or hearing, or that is consistent with their legal duty to disclose the information. So if they provide information in connection with some sort of investigation or formal complaint, then their provision of that information is subject to the anti-retaliation provisions. But employees who have access to this information as part of their essential job duties, who just share it because that's what they have to do as part of their job, they're not protected on those actions. The Virginia Department of Labor and Industry may assess a civil penalty of up to $100 per violation against an employer who violates this law. And then in determining the amount of any penalty to be imposed, the Labor Commissioner will consider the size of the employer and the gravity of the violation. And now I think it's back to David for whistleblowing.
Diana, if you advance to slide 36. Let's see. Okay, Diana, can you hear me?
Yep, we're there.
Okay, great. And on slide 36, this is about the new Virginia whistleblower law. You have in the past all heard about the federal whistleblower laws. This is the same kind of thing, but much broader that they're adopting in Virginia. It applies to any instance in which an employee is reporting in good faith a violation of federal or state law or a federal or state regulation to a supervisor or to any governmental body or any law enforcement official. They're also protected if they're responding to a request from a governmental body or law enforcement to participate in an investigation, hearing, or inquiry. They're protected if they refuse to engage in a criminal act that would subject the employee to criminal liability. Next slide there. Protection also extends to refusing an employer's order to perform an action that violates any federal or state law or regulation when the employee informs the employer that the order is being refused for that reason. And finally, it protects an employee providing information to or testifying before a governmental body or law enforcement official any investigation on alleged violation by the employer of either federal or state law or regulation. Next slide. When I say that this is, the prohibition covers any conduct by an employer. An employer cannot discharge, discipline, threaten to discharge or discipline, cannot discriminate against, which would include reassignment or change of shifts or something else that's viewed as retaliatory, or otherwise penalizing an employee or taking other retaliatory action regarding an employee's compensation, terms, conditions, location, or privileges, reassigning an employee to a different location or a different shift, for instance. Next slide. It does not authorize a whistleblower to make disclosure of data that is otherwise protected by law or privilege. It does not permit an employee to make statements or disclosures knowing that they are false or that they're in reckless disregard of the truth. And it does not permit disclosures that would otherwise violate federal or state law or diminish or impair the rights of another person to protection of confidential information or communications that are provided in other common law. Next slide. This statute, as I said at the intro on it, it's very, very broad. While the federal whistleblower laws are all part of other specific statutes on corporate finance issues or Sarbanes-Oxley, any of the other whistleblower laws, they are parts of a specific statute. This, on the other hand, says in Virginia, whistleblowers are protected, whether it's federal law or state law, whether it's a law or a regulation, whether it's a proceeding, whistleblowers are protected. And so it's extraordinarily broad in that it applies to any perceived violation of any federal or state law. Bottom bullet here to draw your attention to, there is no exhaustion requirement. That means that there are no charges that are filed. When a person contends that they have been harmed as a whistleblower, they are free to go right into court and file an action. Next slide. They can go straight to court within a year of the retaliatory conduct. They can get injunctive relief, reinstatement. You can imagine how effective that will be. Reinstatement to the same or an equivalent position and compensation for lost wages, benefits. This really will open up compensatory damage claims, pain, suffering, humiliation, embarrassment, loss of enjoyment of life, together with interest and attorney's fees and costs. Huge potential recoveries on that. And as a practical matter, if someone prevails and gets an order of reinstatement, then the amount that one pays to avoid reinstatement pushes the total exposure up even higher. Next slide. Oh, and because of our moving back and forth, we've gone through our text material faster than anticipated. I want to take a couple of minutes of just concluding remarks, and then we can open it up for more question and answers. I would urge everyone listening to this to, at a minimum, review your existing policies. There's never been a requirement that you had a handbook. There are some times in which you have been required to provide notice and to include things in a handbook. If you have a handbook, you should review it carefully on making sure that you don't have any policies that are in conflict with any of the wage payment laws that Crystal's already gone through, provisions relating to deductions from pay, for instance, are commonplace. Provisions relating to discussion of pay, while long illegal, have been in many employee handbooks over years. Having internal complaint procedures is often an effective mechanism to try to get an employee to raise an issue internally instead of going right to plaintiff's counsel and filing a lawsuit, because plaintiff's counsel have, in most instances that we've talked about today, they have every incentive to file the case as quickly as they can after that because of the attorney's fee provisions. So they don't want to send a long demand letter and go through a month or two of negotiations. They want to file the case right away. The attorney's fee clock starts clicking certainly by that time. Employers should consider agreements to arbitrate. It is permissible for an employer to require entering into such an agreement as a condition of employment or continued employment. It can also include a waiver of class actions. Crystal pointed out that collective actions are now available on those wage claims. Collective actions, that's the special name given to wage claims that are, you're more familiar with class actions under the discrimination statutes. We have never had class actions in Virginia before. This is the first almost casual adoption of procedures that allow employees to bring collective actions. And so, as a for instance, if an employer has a policy which has, just to give an example on it, if it has automatically deducted a fixed amount from an employee's hours every day for a meal period without regard to whether they actually had that meal period or not, that's the kind of claim that is very well situated to be brought as a collective action. If an attorney gets two employees from one company that say, yeah, this is the company's policy, I got hit by it twice, then the employees' counsel can bring a collective action on behalf of all similarly situated employees who are affected by that same policy. And it can go before the court on behalf of everyone who's been impacted by that employer policy. So class collective actions are going to be a new feature of state court employment litigation. Another reason, I think, to consider agreements to arbitrate with class action waivers. And while I've never been an active promoter of EPLI, employment practices liability insurance, I will tell you that the benefit of coverage will increase with some of these potentially very large verdicts. And quite frankly, I expect that the premiums will dramatically increase on it. So that is not, even in this era of COVID activity, it's not something that you want to look at as an easy thing to strike from your budget. You want to consider that carefully. Okay, those were the points that I had. Diana, what's the best way to invite folks to offer up questions?
Absolutely. So we have two questions in the Q&A, which I'll go ahead and read out to you and you can answer live. And then other people can submit through the Q&A or raise your hand and I'll allow you to talk as those come in. So for the first question from Francesca Jones is it no longer appropriate to pay hourly employees on a semi-monthly basis, 24 pay periods per year?
And I will answer that one. And I'm sorry if I was talking too quickly. I was trying not to get bumped off the Zoom. So I apologize if there's some confusion. That requirement did not change at all. That still stays the same under the Virginia Wage Payment Act. And hourly employees must be paid every other week or at least twice a month.
Great, thank you. And the second question from Kimberly Robinson, can you advise on the law as far as limiting deductions so that the employee at least makes minimum wage after the deductions?
Yes, and I can answer that one too. Under the Virginia Wage Payment Act, which, and this generally corresponds with the Fair Labor Standards Act, but you want to be careful that you're complying with both But under the Virginia Wage Payment Act, no deduction is allowed that will reduce the employee's wage or pay below the amounts provided by the applicable state or federal minimum wage. The only exception to that are deductions from monies that have already been received by the employee in advance of work performed, such as a pay advance or a loan by the employer. And in those particular cases under Virginia state law, it could be appropriate to have the deduction make it so that it goes below minimum wage, but those are the only very limited circumstances.
Great, thank you. Those are the 2 questions that I had. Are there any other ones? If anyone wants to, one more. Jennifer Henderson asking, are you allowed to require employees to make up drawer shortages if you don't take it out of their wages?
Do you want me to answer that one, David, or do you have this one?
Oh, sure. The statute only addresses taking amounts out of it, but I will tell you that with the changes here, I think a person potentially could assert a whistleblower claim. For instance, if you go to them and say, you need to pay $20 back for a drawer shortage, I can't take it out of your pay because of the wage payment law, but I'm going to require that you pay it in cash. I think that you have a much greater risk of some kind of a whistleblower claim being asserted that you're trying to circumvent the law, which in fact you are. So the better solution on that is if you have an employee who has consistent drawer shortages, get rid of them and hire somebody else.
Thanks, David. Next question. Can you have an employee's pay suspended for a violation of company policy?
I don't understand the question exactly, but you cannot make a deduction from an employee's wages or stop paying the employee because they violated a company work rule. They have to be paid for all hours worked. You can suspend an employee without pay as a type of discipline, depending on the situation that might be appropriate, as long as you're not requiring them to work without being paid. Right, David?
Right. And the key thing on this, folks, is you can't ever retroactively take someone's pay or declare that they've been on suspension. You can say, effective tomorrow, you're suspended for 3 days and the employee will not work and therefore will not be paid. Of course, you recall that exempt employees who are paid on a salary basis, you would want to do that for a full week, because they have to receive a full weekly salary for any week in which they have worked. So you would not want to do a 3-day suspension of an exempt salaried employee.
And some further clarification for that question came in. If they have performed poorly and have been placed on a performance improvement plan and still do not improve their performance, and this is all for an hourly employee.
We cannot have people work and not get paid for it. So if that's what the question on suspension of pay is suggesting, then no, it would be unlawful. We have to pay 4 hours worked. We can stop allowing them to work either as a suspension or a discharge, but when they work, they're entitled to the pay for it.
Yes, it was clarified that no, they are not working. So I assume it would fall into the suspension after hours work.
Right, that's an employee suspended from work, correct, and that's permissible.
Yes, thank you. And our next question is, can you still pay piecework if the employee is not at least making minimum wage?
Okay, I'm seeing it, and I think that the question is if the employee is at least making minimum wage. And unless Crystal thinks it's been changed under the Virginia statute, that would still be permissible under the federal wage and hour law.
Yeah, and that's still permissible under the Virginia statute as well. They just have to be making at least minimum wage.
Yep. Okay.
And the next question, can employers require servers to pay for restaurant bills / tabs if a customer walks out without paying?
I'll defer to Crystal. I think it's right in the area she covered. That's the same as being prohibited from charging an employee for a gasoline drive-off at a
That's
convenience.
exactly right. Yeah, that's exactly right.
No longer permissible.
I don't think it's permissible, no.
What is the minimum salary amount that has to be paid for a manager who works over 40 hours?
The Virginia statute doesn't address that. That's still covered under the Federal Fair Labor Standards Act. And you recall, I guess the changes went in back at the end of last year when there was an increase in the minimum salary requirement to meet the exemption. Now, a couple of things to quickly point out. Presumably, we're talking about what's the minimum salary for an exempt, either executive or administrative employee on it. And my recollection is it went up to 37,000. I see Ms. Henderson sent that in. If you want to send me an email, I will send you a link to the Department of Labor fact sheet on that.
Thanks.
And I think that, with that, we have addressed all the open questions, so we should duck out before any more come in. I hope that Crystal and I have provided some information. Diana will make a PDF of the slides available to anyone who requests it. And on the first page of that, it has our email addresses at Jackson Lewis, and we'll be happy to follow up. And no, I promise there won't be any bills for follow-up questions. Thanks a lot. I hope everyone stays safe.
Thank you so much to David and to Crystal. Crystal, go ahead. I didn't want to cut you off.
I'm just saying thank you. That's all.
Well, we so appreciate your time, and I know this has been very informative to everyone. As mentioned, we will share the slides with everyone after the fact, and if you have any other questions, David and Crystal have so generously offered to answer them, and their email and contact information will be included in these slides. So with that, we will go ahead and wrap things up a little bit early and give you some time back in your day. Thank you all so much.
Thank you.
Thanks all.